Chair recognizes Mr. Biggs from Arizona.
Thank you, Mr. Chairman, and thank you, all of the witnesses, for coming in today. Attorney General Schwab, do you remember the case State of Maryland and District of Columbia versus Engage Armament, LC, et cetera?
I do.
And in that case, just for anybody who's not aware of it, the district joined Maryland and sued 3 Maryland firearm retailers for allegedly making straw purchases. In your lawsuit, you engaged 2 outside counsel. One firm, I think it's called Every Town Law, and another was Perkins Coie. Do you remember that?
I do.
And how much did you pay Perkins Coie, and how much did you pay Every Town lawsuit?
Both of those outside firms are on a pro bono basis, so no money has been paid to them.
You didn't pay him anything. Okay. You know, you filed that lawsuit was baseless, right? You'd agree with that now after you've read the verdict of the district court, and I'm going to go through that with you pretty clearly.
Well, Mr. Biggs, as you know, that case has been dismissed and is on appeal, and given the fact that it is still part of active litigation,
you don't want to talk about it. I don't blame you.
I'm not going to talk about the merits while it's in active litigation.
Right. I don't blame you for not wanting to talk about it, because I go through here and at least 10 times the judge said there's absolutely no basis. There's no factual basis for bringing that lawsuit. So that's pretty damning. And not only that, under Maryland law, and basically Arizona's the same way. Most cases is every bit of deference is going to be given to a party who's defending against a motion to dismiss or motion for summary judgment, right? I mean, that's normal. That's Maryland law, right?
Yes, that's the standard.
Yeah. And in this particular case, the judge made some very interesting comments. This is what he said. Ordinarily, leave to amend in Maryland is freely granted, particularly when a case is in an early stage, unless leave to amend would be futile or inappropriate for other reasons. This case presents such an occasion to deny the request, close quote. I don't know, I used to practice, I used to do a lot of trial work. I don't remember ever seeing something like that. That's pretty damning stuff from the court. And then it goes on, the judge goes on to say, at bottom, in the court's view, the plaintiffs hope to use the discovery process in order to construct a case. And the court correctly notes, through that discovery, the plaintiff wants to find sufficient facts to state a viable claim for relief. But right then, in the complaint, failed to state any claim for relief. And so, the question that's begged here is, why wasn't a Rule 11 sanction brought against you and the other plaintiffs' attorneys? Was a Rule 11 sanction brought?
No, sir, and while we obviously disagree with that ruling, we are pursuing an appeal as the rules allow us to do, and I'm confident that we'll get it turned around at the Court of Appeals.
Yeah, of course, you were confident you were going to win the case when you didn't have jack squat, but you went after 3 FFLs because you had a political agenda. There were no sanctions. Did you have to pay attorney's fees or costs? Were any of those ordered? I didn't see them ordered in here. I assume they weren't ordered.
There were no sanctions. There were no costs.
So,
the important thing is we were working as hard as we can in this city to keep illegal guns out.
No, the important thing is,
and the
no, sir, no, listen to me for a second. Listen to me for a second. The important thing, Mr. Attorney General Schwab, the important thing was that you were using your office to abuse gun FFLs because you don't like them, and that's the deal. Because as the judge said, you basically didn't have a case whatsoever. But you decided to use your power and your authority and make the process the punishment. That's what you chose to do. That's what you chose to do, and there's no question before you.
That is not true, sir.
That's exactly what this says. And that's a shame, because that's an abuse of power right there. And so you come in here, sit here, and tell us all this righteousness about power. But I'm telling you, when you're using the process itself to go after political opponents, which is exactly what you're doing. This is a philosophical issue that you have, and you used them, and you you used 2 firms that you know and I know that that's their motive. The law firm, every state, that is their job. That's what they want to do. They solicit funds to go out there and sue FFLs because they don't want the Second Amendment to even exist. Read their statements. And you joined with them. Mayor Bowser, It's good to see you again. I know you do have a tough job. I'm the first to admit it.
Thank you.
But it's good to see you again.
Thank you.
And I'm out of time, so I can't ask any questions, but I do have some things I want to, Mr. Chairman, I have some UCs.
Yes, proceed.
First of all, I wanted to introduce the memorandum decision and order from the case State of Maryland, D.C. versus Engage Armament et al.
Without objection, so ordered.
The letter from the committee to the Honorable Brian L. Schwab dated June 11, 2025,
Without objection, so ordered.
which we're still waiting for answers for. This one, Mayor Muriel Bowser says Trump's surge of federal law enforcement has lowered crime in D.C.
Without objection, so ordered.
Trump's D.C. crime crackdown busts another alleged Tren de Aragua gang member. Make
That-
D.C. safe again.
Without objection, so ordered.
This one, Trump's executive orders target D.C. crime as the city hits 12 days without a homicide.
Without objection, so ordered.
This one is radical D.C. officials treated officers like crap, police leader says.
Without objection, so ordered.
Murdered congressional intern's mom says Trump should take over Washington, D.C.
Without objection, so ordered.
Yes, prosecuting and arresting criminals would have immediate impact on D.C.'s crime.
Without objection, so ordered.
Thank you, Mr. Chairman.
Thank you.